Persons that have a potential medical malpractice claim don't understand or need to be informed about a few topics. First one is the amount of time it takes. I think unlike other areas of injury law, medical malpractice is significantly more time consuming because it's more complex. And so both the investigation before you bring a lawsuit, the pre-litigation process that you have to do before, and the litigation itself just really delay things. And then you combine that with the schedules of the doctors you need to talk to, both at fault and not at fault, the defense attorneys' calendars, the court's calendars. It's a long process. So the first thing we do is educate clients that we're in it for a long ride. Unlike the auto insurance world, where if you're in an accident and you think it's the other person's fault, if your insurance decides it's your fault and they should settle the claim, they're going to do it without your permission. In medical malpractice, a physician can say, no, don't settle, and his insurance company can't settle unless the physician wants to. So that sometimes is the delay. What I see more often, and is more troubling, is that I see physicians that would like to settle the case, but the insurance company is refusing or not being reasonable in the amount, and they want to drag it out, and they want to fight it. But an average case time, not just for our office, for anybody, is 3 years or more. And it's hard for clients to understand that. And if we could change it and make it faster, we absolutely would. We do everything we can to move it faster, but the first thing clients need to understand is this is a long process. Another frequent question we get is about the pre-litigation requirements. And this is what makes our field kind of specialized. If in any other injury case, you don't have to do this. But if your injury involves any type of healthcare provider, from a sports medicine doctor, a chiropractor, even a holistic medicine person that doesn't have a real license, if they provide any sort of arguably healthcare, then laser, Botox, anything, you have to go through a pre-litigation process. You have to tell them, hey, I'm thinking about suing you, give them notice, and then a panel is appointed that involves local providers and lay people that sit on the panel, and you have to go before them and kind of tell your case, and the defense shows up and tells their case, and then they make a decision whether the case has merit or not. And you have to get that decision and jump through that hoop, and it takes usually 6 months to do that. So from the time we get a case, we need a couple months to gather the records, which there's laws about how quick we are allowed to demand records. They have time to produce those. And then file the notice of intent, have the pre-litigation hearing. That takes 6 months. So sometimes it's a year before you can even fully investigate the case and get answers about whether you should file a lawsuit and whether you have a case. And then once you do, you start the case, and then it's years after that before a potential settlement or trial comes into play. The next thing we get questions about are costs. So medical malpractice, the reason, I think one of the reasons a lot of our cases come from other lawyers is it's one of the most expensive forms of litigation. In any given case, we need to talk to probably 20 different doctors. Some of them are ones we hire to be experts in the case. Some of them are our clients' treating providers who have information that's important to the case, but they're not there to opine on whether somebody made a mistake or not. But they still get paid to show up to their depositions. They're not going to come for free. We have to pay the court reporter who's there in the deposition. We have to pay the treating providers who are coming to give information. We have to pay the experts who are reviewing the case to give us opinions. We can have cases that are up to $100,000 before you even go to trial. We've spent $100,000 in the case. And then through trial, we've had them as high as $250,000 that we've written checks for. That's not our time, that's not our staff's time, that's hard costs in the case. And we front all of those for our clients. And so that's a risk we take. If we lose, that money is gone along with our time. And so costs are a big hurdle. Because medical malpractice is so expensive, you have to be creative in trying to get them done efficiently so that maybe the case value is $100,000. If it costs $60 to get to trial, and then you win $100, in the end, the client's going to be unhappy because most of the money goes to the experts and the court reporters and the filing fees, and there's very little left for the client or the attorney. And so we've gotten good at identifying cases that even though they're not high value or major injuries, you can still make them work. And sometimes it's just principle thing. I've taken cases where we lose money and I know we're going to lose money, but I'm so frustrated that this happened to somebody and they shouldn't get away with it just because they only hurt them a little. They didn't hurt them a lot. In Utah, medical malpractice cases have to be brought within a certain time period. And that makes it difficult because the time period is different depending on who made the medical error. If it is a person who's employed by the University of Utah, which might work at the VA, they might work at IMC, it's hard to know where they're working, but if they're employed by the University of Utah and working within that realm, meaning the University of Utah has a contract to send them there, then the statute to notify them of a claim is 1 year. If they don't work with the University of Utah, you have 2 years. And sometimes in medicine, you don't know that there's been an error for time. You might get a scan and they tell you it's normal, and then 4 years later you find out it was cancer, there was cancer on that scan, and no one told you. Now the 2 years is up, and in Utah you can extend that 2 years a few years, but no more than 4. If the negligence happened 4 years ago or more, with very, very few exceptions, you have no case. And the laws aren't fair, but that's another thing people have trouble understanding is, when we can take a case and not take a case based on when they come in. That's why it's important to contact a lawyer early and make sure that you don't miss your chance to at least investigate the case and get answers. I get a lot of sad cases that seem like they're clearly a case, but they waited so long because they've been grieving or didn't understand what happened, and it's been over 4 years or it's been past 2, and it's going to be tricky to prove that they can bring a case. Health insurance has the right to recover. Some health insurances have the right to recover from your settlement. And so it's hard for clients to accept that they have to pay a lawyer, they have to pay their health insurance back, and then what's left, the original settlement doesn't make them whole. They're still injured and they still wouldn't trade what they lost for this money, and then after attorney's fees, and then you have to pay your health insurance back. We negotiate with those health insurances and try and get something fair and make them pay their share of attorney's fees so they don't just get all their money back without having to pay the lawyer, and the client has to pay the lawyer. But liens and health insurance payback is a big surprise to a lot of clients.